Good afternoon. My name is Alex Nagaris, a partner in Venable's New York office. My practice largely involves defending companies of all shapes and sizes before the CFPB, including non-public investigations and appeals of examination findings or ratings. Companies must work harder than ever to adequately secure and protect their intellectual property, financial information, marketing and business plans, and sensitive client and customer information. For companies in the financial services space, the collection, storage, transfer, and analysis of sensitive customer data is the lifeblood of the business. As the sources of data security threats multiply, so do the sources of regulation. And today we'll be talking about one such source, the CFPB. Venable is uniquely positioned to help financial services companies navigate the strategic, operational, risk management needs of large-scale technology environments. Our cybersecurity services team is comprised of lawyers and cybersecurity professionals, two of whom are here with us today with extensive experience in both public and private sectors. And they work with organizations to identify and address threats and weaknesses in their systems and to assess compliance with the patchwork of laws that regulate data. And our financial services group is steeped in the specific laws and regs that apply to financial services and the inner workings of the regulators. So let me introduce first my co-stars. Andrew Bigger is a partner in our Washington, DC office and also the co-chair of our financial services practice group. He focuses his practice on helping bank and non-bank financial institutions navigate the federal and state regulatory environment, governing payments, lending, and consumer financial services broadly. Jeremy Grant is a member of Venable's cybersecurity risk management group. He has served in a range of leadership positions spanning government and industry. He uses that experience to advise clients across IT, cybersecurity, identity, and the payments sectors. And last but not least, Ross Nordorf counsels clients on issues related to risk management, government policy, and compliance and incident management. Ross has served as principal of risk management and government solutions at a cybersecurity firm and served as chief of the Office of Management and Budget cyber team in the White House, overseeing federal government cybersecurity policy. And so what are we going to discuss today? First, we'll kick things off with the CFPB's circular that it issued this past August relating to whether or not data security issues can be potential violations in organic statute. Talk about what that circular said, what it is, what it isn't, and then we'll jump into the meat of kind of the specific measures that circular called out that all financial services companies should have in place in order to prevent violations of its statute and UDAP. And then finally, Andrew will bring it home, covering kind of some unique challenges in data security that's presented by the open banking as a service, and modern payment system, where companies are increasingly working together and sharing consumer information. So first, what is the circular? So as mentioned, in August of this past summer, the CFPB issued the circular that presented the question, can entities violate the prohibition on unfair acts in the Consumer Financial Protection Act when they have insufficient data protection or information security? And the circular went on to say, yes, it can constitute a UDAP in violation of the CFPA to have core data security protections in place. And it went on to describe some measures that it believes are low cost and efficient for companies to have in place in order to not find itself in violation of the statute. But first, before we get into that, why is this important? Well, first, the CFPB's jurisdiction, all of on this webinar, is extremely broad. All financial services companies and their service providers are subject to the statute. And not only that, but covered persons under the statute include individuals that run the businesses, that own the businesses. So the CFPB's reach under its organic statute is very broad. And of course, the remedies available to the CFPB under the CFPA are expansive. This includes being able to ask a court to shut down the business or the practice that it believes is in violation of the law. The CFPB can and does have the ability to obtain consumer redress, typically in the form of customer refunds. And then also it has the ability to issue civil penalties for per violation, which is something that the FTC, for example, doesn't have authority to do for first-time offenders. And so the CFPB, as a result, has a very big stick to carry and leverage for companies that it's both examining in its regular supervision examinations, but also bringing in investigations just to look at data security issues. Thinking of following a breach, it can now not only open an investigation to see if that breach was caused by unfair conduct, and we'll talk a little bit about what that means. So first, what is a circular and what is its effect? The Consumer Financial Protection circulars are policy statements advising parties with authority to enforce consumer financial law, such as states attorney general, the Department of Justice, the Federal Trade Commission. So these documents that are created by the CFPB are designed for other regulators and law enforcement agencies to understand kind of the CFPB's interpretation or understanding of a given issue. They are general statements of policy under the APA. They're not subject to notice and comment like a regulation would be. And they're also not supposed to impose any new legal requirement. This specific circular, said, very matter-of-factly that this is the CFPB director instructing staff, as described herein in the circular, and the CFPB will then make any final decisions on individual matters based on an assessment of the factual record, applicable law, and factors related to prosecutorial discretion. But in doing so and calling out these specific data security issues, the CFPB is taking a position on these practices. It is, in a sense, threatening that it will, bring enforcement actions under the CFPA for, lax data security measures. And it's also telling its counterparts, both in other sister agencies in the federal government, but also state attorneys general, that they should and could enforce the CFPA when there are data security lapses. The state attorneys general do have the authority to enforce the CFPA. You haven't really seen it since the CFPB has been around, but this CFPB under the current director has issued multiple guidance type documents like this one, hinting or signaling to the states that it should be using the CFPA more aggressively or in certain ways against companies that operate in their states. And so the circular very much is a message to industry, but also to other government agencies and regulators as to how to use the CFPA with respect to information security until at least there's more regulations out there. This is not the CFPB's first time putting its thumb on the scale with respect to data security. As Andrew will discuss in a moment, it's been for years now, issuing requests for information and comments, and on the road to issuing regulations. In 2017, it issued a set of 9 principles for industry, financial services companies to take into account when designing their information systems, in terms of making sure that they're protecting the data from a perspective of protecting the consumer. And so these are the 9 principles. Again, these were just standards that were put out there, did not have a force of law, didn't actually require specific measures that companies had to undertake. Again, just setting out some standards for industry. This now circular seems to go a little bit further. And so, Andrew, if you want to talk a little bit about the rulemaking.
Yeah, no, and it's, I think the timing for a lot of these things are not a coincidence. The circular that came out on data security, you've got the CFPB's ongoing rulemaking on consumer permission data, or open banking, and then a lot of other either papers coming out of the CFPB or statements from Director Chopra really focusing in on the concepts of data use, data access, and data security. In addition to the open banking 1033 rule, which we'll talk a little bit more now, you've got the CFPB last year issuing the big tech orders to a bunch of the big tech companies, trying to find out, what are you doing in terms of gathering consumer data? How are you using it? That's been a really big focus. There's been a big focus from the CFPB on super apps and embedded finance and related issues like that. So it's really, all of these things are coming together where at the CFPB right now, they're really focused on data use, data access, and a big part of that is data security. When we talk about 1033 and open banking, just want to quickly hit on some of the key kind of defined terms. And these are really pulled directly from the CFPB's ongoing rulemaking. You've got 3 main entities. You've got data holders, which are generally your traditional financial institutions, banks, credit unions that have customer relationships. They have access to data, and these are referred to as data holders. You've got data aggregators, which are the kind of the middlemen entities that help move and gather data and provide access for non-banks that want to have access to the data that the data holders have. And that connection is increasingly being done through APIs and technology that has kind of an automatic connection. If you look a few years ago, it was very much kind of screen scraping or using kind of consumer credentials and other ways to do that. But now it's really moving more towards an API model, which a lot of people think the CFPB may come out with some basic standards governing that. And then finally, you've got the data user, which is going to be the Fintech, the other non-bank provider of financial services that's looking to access that consumer information that resides with the data holder so that they can either approve a consumer to get products and services or actually use that data in connection with providing services to a consumer. So those are kind of the key players in open banking. Go to the next slide, Alex. So what exactly is the CFPB rulemaking on open banking looking to do? Well, it's actually it's a requirement from Section 1033 Dodd-Frank, the Consumer Financial Protection Act, which requires covered persons, upon the request of a consumer, to provide access to information that the covered person has: transaction information on series of transactions, account, cost, all sorts of information that they may be retaining. That information has to be provided in a format that's usable by consumers, but there isn't necessarily any kind of requirement that a certain type of record be maintained. But the records that are maintained, that are requested, they have to be provided in a usable format. And of course, there are certain exceptions that make sense in a lot of cases to what type of information has to be provided. A covered person, the banks, the credit union, they don't have to provide confidential commercial information, which might include, for example, information on their algorithms that they're using internally for underwriting or other risk type analysis. They don't have to provide information that's being used to prevent fraud or anti-money laundering related tools, et cetera, or anything else kind of required by law to be confidential. It really is focused on giving consumers and third parties consumers are working with access to kind of the transactional day-to-day information regarding the consumer's account with the financial institution. Next slide. As Alex mentioned, it's been a rulemaking that's been in progress now for a while. The CFPB is definitely taking its time on it. I think the latest information is that they're kind of going through the small business review phase now. So we're looking at most likely within the next few months resolution to this. But they've come out with their principles statement, as Alex noted. They've come out with their proposed rulemaking, and I think that the types of issues that have caused this maybe to be a little bit delayed are with a new CFPB director, Chopra, really looking at kind of the privacy issues that are implicated by part of this, the data use issues. And then there's really a whole host of other legal considerations that financial institutions are going to be looking for in terms of guidance from this rule. What kind of regulatory supervision is going to be imposed on data aggregators or the users of data, which, banks, and credit unions, they've got their existing GLBA obligations. We'll talk a little bit more about how some of the non-banks are now getting pulled into some of that, but what's going to be the regulatory framework for the non-banks that are accessing this information? How do you manage liability when you've got a bank sharing information with a non-bank? If something does go wrong with that data and a consumer is harmed, which party should bear the liability for that, and under what circumstances? What kind of risk management and third-party oversight do banks need to perform with the entities that they're providing access to? It's not a typical third-party vendor relationship, but should there be some kind of due diligence obligations? And then really, perhaps even most importantly, and based on what we're talking about today, what are the data security expectations? Banks right now, they have a lot of data security expectations for managing the data that they're holding. As they share that with non-banks, what are the expectations for how they're going to manage the security of all this new data that they're now going to have, or increasingly will have access to? So those are really the kind of the key issues that I think we're looking to get guidance from coming out of this rulemaking. But Alex, certainly this rulemaking is just one kind of development to keep an eye on. There's been other developments as well.
As Andrew mentioned, there is an existing framework, and that stems from the Round-Leach Act, which has been around for a long time, and the regulations that the FTC has implemented under them for non-bank financial services companies. The Safeguards Rule, which was first promulgated in, I think, 2003, was recently updated to reflect new technologies and new considerations. The Safeguards Rule, again, applies to non-banking financial institutions, and the rule itself lists the type of organizations that it covers, such as check cashing businesses, mortgage brokers, non-bank lenders, even professional tax preparers. So the definition is broader than what many would consider to be a financial institution. Under the new rule, the updated rule, the scope of institutions has been extended to cover binders, and it also still does not apply to service providers, but any company that is subject to the revised Safeguards rules will, of course, insist that their service providers be subject to the same safeguard requirements contractually in order to meet their obligations in turn with the regulation. As compared with the original Safeguards rule, this final rule has a lot more details with respect to the substantive requirements of the program. We'll talk about those in a bit. And October 27th, which is the effective date, is just around the corner. So most organizations subject to the Safeguards rule have spent considerable amount of time thinking about how to implement these changes and are far along in that process.
As noted, the updated rule provides a lot more guidance and specificity on what's required to have a good program. The rule requires implementation and review of access controls, encryption of customer information, both in transit and at rest. Requires companies to develop, implement, and maintain information disposal practices, and adopt change management procedures. And then, of course, for banks, the GLBA also still applies. The prudential regulators have the authority to kind of issue the guidance and rules that apply to banks. In 2001, the prudential regulators issued a joint rule, the interagency guidelines establishing information security standards, which every bank is very familiar with. It sets standards for developing and implementing both the administrative, technical, and physical safeguards to protect integrity of customer information. So back to the circular. So why is the circular even necessary given this patchwork of requirements stemming from GLBA? The upcoming rule that the CFPB is in the process of issuing. First, as noted before, this gives the CFPB more leverage when both examining and investigating companies. By saying that it could be an unfair practice, it puts companies on notice that they need to ensure that the customer experience is being taken into consideration when dealing with the collection, storage, and transfer of their data. The CFPB said specifically in the circular, when companies forego reasonable, cost-efficient measures to protect consumer data, the CFPB expects the risk of substantial injury to consumers will outweigh any purported countervailing benefits to consumers and competition. Essentially setting up that the lack of these certain measures, which we'll discuss in some detail, is unfair to customers because it is necessarily going to injure them and not have outweighing benefits. And so the specific, reasonable, cost-efficient measures that were called out by the CFPB in the circular include multi-factor authentication, password management, and timely software updates. And so I will turn it now over to Jeremy.
Yeah, Alex, just one quick thing before we jump to Jeremy to walk us through the technology is what's interesting about the circular is they're really emphasizing this issue, but it's not like there haven't been some enforcement actions already in the past, right? I mean, the FTC has brought some enforcement actions for deceptive statements, for example, that companies make about their data security standards when they're not actually true. And the CFPB has done that as well in the past, including against payments companies. So I think that, it's not while the circular is kind of flagging this issue, it's not a theoretical issue. It is an enforcement risk that they've actually undertaken in the past. And that's why I think it's important to kind of mind this guidance and especially some of the technology issues that Jeremy and his team is going to walk through.
Thanks, Andrew. And that's a great intro. If we can skip to the MFA section. So let's dive a little into what CFPB actually had to say around MFA. So, they flagged up front, I think some things most people know in the security space. Multi-factor authentication is a security enhancement that requires multiple credentials or factors of authentication before an account can be accessed. So that generally means how do you complement something like a password with something you have, perhaps like a physical token or a smartphone can, be a proof of possession, and something you might be like a fingerprint or, a face unlock on a device. So, traditionally we've seen MFA, and they talk about this here, where you are using a password and then a second factor on top of that. Say like a temporary one-time passcode that you might get from an authentication app or that might be texted to you. And they talk about things like hardware authentication devices, the one I'm holding up here, which is a FIDO security key. We'll come back to that in a minute. And they flag that, if you're using MFA, it makes it a lot harder given all of the attacks in cyberspace that we see focused on credential compromise for an attacker to actually be successful. What's notable here, I'm going to come back to this in a few slides, is they're specifically saying that we want to look at MFA solutions that can protect against credential phishing, such as those using the Web Authentication standard. And we'll dive a little more into what that means. And then, to the point that Andrew and Alex were making, they're also saying, if you're not requiring MFA for your employees, if you're not offering MFA as an option for your consumers, or you don't have some sort of other compensating control that's a reasonably secure equivalent, it might trigger liability if there's some sort of an incident. So what's new here? Well, let's dive into the next slide if you can advance. There's, I think, a couple things. Let's go one back, actually. Sorry. So historically, financial institutions have been, guided, say, for the last 21 years, the FFIEC has had guidance on authentication and access to FI services and systems. And it's basically laid out a, criteria for financial institutions to take a risk-based approach to authentication. You can generally read it and say you should be using MFA, but there's not necessarily a mandate. So I think that's what's different here is that CFPB is the first regulator I've seen in the financial services space in the US to get more prescriptive, basically signaling if you're not using multi-factor authentication, there's going to be consequences. And they're also digging into the idea of using the right MFA, the idea that some legacy MFA tools aren't going to adequately guard against credential phishing attacks. So on the next slide, I think one other thing that's new here is something I don't think I've ever seen a financial regulator do, which is, look, we've seen many of them over the years issue guidance. This is the first time I've seen a regulator post a tweet that says, if your financial institution isn't offering you MFA, you should submit a complaint to us. I'd say this is a little bit of a different posture, certainly a little bit more activist than we've seen the regulators take in the past. So I want to shift on the next slide now, if you can click, not once, but twice, the web authentication standard. So what are they actually talking about here? Well, part of what they're getting at here is, if you go to the next slide, we've had a real challenge with some of the first types of tools that we've been using for multi-factor authentication. The attackers have caught up, and we're at a really interesting inflection point in the security industry where what used to be good enough a few years ago isn't good enough now. So I tend to, look at MFA from a perspective of what I would say is legacy MFA and then more modern MFA. The legacy tools, things that might require a one-time passcode, or you have an app that you get a push notification and you click, yes, I'm trying to log in. Well, that's not as secure as it used to be because the attackers have been innovating now that this has been more widely deployed. And so just like they can phish one of your customers or one of your employees' passwords, well, if you then have a second passcode, a one-time passcode that's good for 30 seconds, well, they can trick you into handing over that code as well. And it turns out that 30 seconds is plenty of time to do an account takeover. Likewise, if you're getting a push notification on an app and you're getting that prompt, well, you can trick people into pushing yes. In fact, one of the things we've been seeing in breaches this last year has been what people are calling MFA fatigue, which is I'm an attacker, I've already got your username and password, and I'm going to just keep logging in every 30 seconds. And it's, keeps, bombing your phone with notifications. And eventually you go, oi, I've had enough. You click yes. And, all they have to do is be wrong once. And the attackers, take in control. We're also seeing this being used particularly with some admins in firms with what people call smishing attacks, SMS phishing attacks, where you'll get a text that purports to be from somebody in your IT shop saying, hey, click here and log in, we got a problem. And there they'll capture your password and have you push approve on the MFA prompt, and then you're in. So the attack vector has really changed. And the old stuff, look, it's always better to use any MFA than none at all. But if you're really trying to keep a determined attacker out, well, the old stuff's not going to cut it. So on the next slide, let's talk about why they're calling out the web authentication standard. So what is it? Well, web authentication is a newer authentication standard. It's also known as FIDO authentication, after the FIDO Alliance, which is the standards group that created it, that is different in that it can guard against these credential phishing attacks. And Alex, if you can just click one more time, I'll pop up a tweet from Jen Easterly, who's the director of CISA, the Departments of Homeland Security's Cybersecurity and Information Security Agency. CISA's called FIDO the gold standard of MFA, and they've been doing tweets like, the one you saw from Jen a few months ago, pointing out why you really should be looking to FIDO and other phishing-resistant MFA as opposed to some of these legacy items. And one of the things that CFPB also called out is, in the past, if you were trying to implement MFA, it could be a real hassle in that it was something you were looking to bolt on. What's interesting about the FIDO web authentication standard is it's basically built in today out of the box into every major browser, every device you get, regardless of the operating systems, because all these companies have been collaborating on a standard that they're then baking into the devices and browsers and software. So it means the barrier to implementing MFA is lower than it might have been with, say, one-time passcode tokens. And the support that you're seeing from what I would call big tech providers is quite significant. So our take from a security perspective is, on balance, CFPB is on the right track here. Attackers have caught up with legacy MFA, and the best thing you can do to mitigate the risk is look to things like the FIDO Web Authentication standard internally and for consumers. Before I hand it over to Ross to talk about password management, I just wanted to talk a little bit about some of the things Andrew was hitting before about Section 1033 and the regs we might see later this year, early next year in draft form around consumer access to financial data. Because what we're seeing here from CFPB, I think is an important signal. And let me explain what I mean. For years, the way that most consumers have accessed some third-party fintech apps and been able to give those apps access to their bank data has been through third-party aggregators, most of whom are relying on essentially storing your username and password and then using that to log in on behalf of the consumer, to essentially get the bank data that's needed to make the fintech app run. And what we've seen in the past is when some early banks have tried to turn on MFA for consumers, it breaks that model. Because if I'm just storing a static secret over here, username and password, well, hey, I can log in 5 times a day. What if that code is only good for 30 seconds? Or what if it requires some sort of proof of possession, like a secure cryptographic key that's stored in your smartphone? So the old screen scraping model based on credential caching gets broken with most MFA implementations. And the only way it works is if you're embracing an API model that Andrew talked about before, where you instead would basically, use an API that would, be connected between the fintech app and your bank to have, log in directly to your bank and authorize that particular app to access particular data. And so, my big takeaway from this is if the CFPB is really focusing on the importance of MFA and phishing resistant MFA, it's a good sign that what you're going to see in the regs in a few months is likely to focus on the API model. Our advice to clients would be look at some of the work that's going on in groups like FDX, Financial Data Exchange, where you have the banks and the fintechs working on standards around an API. We've known that's the future technically for a while, but I think there's going to be a regulatory push that certainly from a security perspective, we're getting hints of now in terms of where things are going. Now I'm going to turn things over to my colleague, Ross Noder, to talk about another layer of their authentication guidance on password management.
Before we turn to Ross, let me make the CLE announcement for those of you interested in getting CLE credit. It is CFPB 2022. And with that.
Great. Thanks, Jeremy. Thanks, Alex. So password management. Before we get into the other 2 components that are listed in the circular, I do want to take a step back and look at what the 3 areas are that they're hitting and kind of make sure that you all are keeping in mind the theme that Jeremy raised, which is we are at a point now where the old way of doing security is now being superseded by the attackers that are looking for ways to get through. So what you're seeing in this circular is an acknowledgement of that and a call to up the level of the way that you are protecting your passwords, your identity, and making sure that your software is up to date, right? So those are the big 3, 2 of which are around identity and 1 of which is around software management. So I think it's really important, given that it's a CFPB circular, to keep in mind that they're very much focused on the identity attack vectors, both identity attack vectors that impact the enterprise as well as identity attack vectors that impact the consumers themselves. So the second of the 3 areas that the circular calls out is password management. Specifically, they call out having good password management as a whole. And then the second thing that they do is they identify examples, right? So this includes failing to have processes in place to monitor for breaches at other entities, as well as use of default enterprise passwords and login, making sure that you're not using default enterprise passwords and logins that are reusable. So next slide. So, back to the question, why now? Why are we looking at this? Similar to the way that Jeremy approached it, we've had a series of incidents that have proven that the attackers are moving beyond the old way of doing business. So there is increased use of hardware and software capabilities that allow for attacking the old method of hashing passwords, right? So it allows them to supersede that, scrape that data, and then use those passwords. Two, there has been a glut of accumulated passwords, bad passwords, from breaches spanning the last decade plus. So those old passwords are available online, which is part of the reason that CFPB is directly pointing to monitoring for breached passwords. And we're having new attacks every day. So as you can see in the slide, we talk about accumulated bad passwords from other breaches. There's 12 billion breached accounts out there. Those passwords are available online. People are scraping that data and doing password spraying until they can crack in. And in spite of what people may think, people use the same passwords over and over and over again. The last one is some of the password manager applications that we're talking about here have also started to be breached. So in this year alone, there was a hack of LastPass, which people use to aggregate their passwords and provide access to the account. So as attackers are identifying and looking for more passwords, it's important that we are putting processes in place to mitigate the availability of those passwords. Next slide, please. So what is the foundation for what good password management looks like? Well, NIST has issued special publication 863. They're currently in their third revision, and the digital identity guidelines state what good password management practices look like. So I will note, before we get into exactly what that entails, that CFPB's mention of monitoring for password breaches at other entities actually goes above and beyond the threshold currently identified in the NIST guidance. I will also note that NIST's publication 863 is going through its fourth revision as we speak, and we expect that draft update to the standard to come out in the next couple months. So we could see changes to that password management practices in that document, be edited or be updated to reflect the current attack vectors that we're seeing. Next slide. So I was specifically want to touch on right now what what types of availability we have for monitoring breached passwords. So we've got in-depth password databases that can be purchased, right? There are currently firms that are producing these passwords. There's also enterprise IT companies that provide several different tools and services that are including password database monitoring and breach monitoring services. There's also free resources that can be incorporated in any security plan and system in order to meet the threshold of monitoring at your organization. Next slide. What else would what I want to cover now is what else is considered best practice by NIST in their special publication guidance, and there's four areas I want to call out. Three are proactive, and one is making sure that you're actually not doing something. So first, making sure that you're using secure cryptographical practices to protect the passwords, both in transit and at rest. And I think it's important to pay attention to this right now. If you're not using the appropriate levels of encryption, that is going to be considered an area that I think CFPB could look at. Another one is rate limiting. So in other words, attempts at logging in, you need to limit the number of tries that people take in order to get their password right. Using the appropriate composition and complexity rules, although this is currently being debated in the security space right now, is the effectiveness. Right now, it's still considered a standard that is good practice. And then the final one that I want to highlight is the avoiding use of arbitrary password requirements and password expiration timelines. So people forget, and if you start requiring updates to passwords throughout your enterprise on a regular basis, and we've all done it before, people start to use the same types of passwords with small tweaks and changes that eventually, when there's breached password databases out there, attackers are going to be able to solve for those reuses and access based on old password information. Next slide, please. So before we get into this, I want to give Jeremy a chance because I know he's got some thoughts on the password management as well.
Yeah, before we get into the software updates, I just wanted to flag, I think what we've seen in practice, tracking where the CFPB is getting this from, it's become something that we've seen a lot of both the big cloud providers as well as some of the big identity and access management software firms over the last few years have started to build this functionality into their system. So you might have experienced this. You're creating an account on your smartphone or with some service provider, and it'll say, hey, that password has shown up in a breach somewhere before. You might want to change it. Or you'll get a prompt from, somebody you have an account with that says, hey, we looked at your password. That got, burned someplace else. One of the issues is people reuse passwords across multiple sites. And so if it's been cracked in one area, on one site from a breach, the first thing the hackers will do is take that email and password and start plugging in other places and seeing where it works. So what you're seeing these days, I think in terms of practical advice, knowing, this is mostly legal and compliance folks on this call, talk to the folks in your CISO organization. Try and understand what your identity and access management capabilities are. I'd say if you have, done an upgrade the last couple of years, odds are pretty decent because most of the big commercial firms that sell these solutions are now building this in as a feature. Well, they'll look at a password somebody enters and tell you whether it's shown up in a breach or not, then you need something different. But if you're running something that's a little older, you got legacy here, you probably don't have that functionality. And so I think this is where you might now have a risk in your organizations based on what CFPB put out. Well, look, you already had a risk on the security side, but now there's a regulatory issue as well. And so I would, advise people to, talk to their information security teams, talk to their identity and access management teams, and see if this is a function that they have in place or can easily put in place. Back to you, Ross.
Great. So the last area that is covered in the circular has to do with updates of timely updates of software. So there are systems, software, and code bases throughout your organization that underpin the enterprise as well as the interfaces with customers. All of these areas it's extraordinarily important that we are constantly patching. And we'll get into this in a little bit, but the circular itself calls out. It's interesting in what it calls out specifically. So one, their liability, it could be triggered by not routinely updating systems, software, and code, and two, failure to update when notified of a critical vulnerability. The other interesting part of the circular is it says that you're responsible for maintaining an inventory of software assets along with the dependencies across the organization which your software touches. And you're also responsible for ensuring that regular updates are being done across your organization. And it also includes those updates for software used by contractors to your organization. Next slide, please. So why are we looking at this? Why is this one of the three buckets and areas? Because as CFPB notes actually in the circular, the Equifax breach that led to half of the social security numbers being released into the wild was accused of not maintaining their software repositories, and it was rife with known vulnerabilities. They also talk about the complaint itself talks about and references using and leveraging something called the common vulnerability enumeration or critical vulnerabilities, which likely refers to vulnerabilities scored through the National Vulnerability Database and using the common vulnerability scoring system that NIST maintains. Next slide. So to be very clear here, and this is something, again, to Jeremy's point, as you're talking with your security professionals, we can never expect that there's going to be perfect a perfect asset vulnerability and patch management. It's very, very difficult to do this in any way across a large organization or enterprise. That said, there should be processes in place to monitor for notifications. There should be processes in place to regularly patch software and systems. And usually enterprises are doing this in a risk-based approach. In other words, you have services and systems that are critical to the functionality of the organization. Those are prioritized first for patching, and then you go down your risk ranking and you get to some of the areas of software in your organization that do not have as many dependencies on them, and those are usually patched later on in the processes. CFPB implies a minimum level of due diligence to mitigate for the potential found liable in the case of a breach. So it's routinely checking for updates to software. It's maintaining a reliable inventory of software assets across your enterprise. And then it's routinely cross-checking that inventory against a list of known vulnerabilities. Next slide, please. So there are, and this steps back a little bit, there's a lot of discussion right now in and around the security community about use of broader secure software development and secure software practices. The NTIA, the National Telecommunications Information Industry, has released a software bill of materials publication. There are other provisions being included in legislation that focuses on the public sector entities for requiring certain secure software practices. So I bring this up just to say that this is an area that's being looked at across the security enterprise right now. And as CFPB is rolling out this circular, it portends more focus on software, because software is underpinning more and more of the processes we're doing as we're moving into a more digital economy. Anybody else have any questions or comments on this one? All right, next slide. Back to you, Andrew.
Yeah. So, we've talked a lot about the CFPB's focus on data security. We've talked about CFPB and other regulator interest in protecting consumer information and all the best practices that Jeremy and Ross talked about. And a lot of that we talked about in the context of open banking and kind of the sharing of data between financial institutions and non-bank financial institutions. But open banking is just kind of one aspect of what we're seeing in the market, which is a lot of different ways that fintechs and banks and other entities are sharing information, right? Where open banking is really kind of consumer permissioned, non-bank access to information maintained by financial institutions so that non-bank can provide services. A traditional kind of bank or fintech partnership is more where you have a bank and a fintech working together to provide a service directly to a consumer. And in both cases, we're talking about collaborations involving banks and fintechs to provide services, but it's just a little bit different in terms of the nature of the relationship. What's not different, though, is that you still have all these issues that we've talked about of consumer permission to get access to consumer information, how it's being used, what kind of disclosures are being made to consumers, and finally, what kind of data security is being implemented both on the bank side or on the fintech partner side to protect information. And just in terms of, we'll walk through some of these, some of the issues with, bank and fintech partnerships, but there's a lot of different use cases and models that we see out there. A lot of this overlaps with what you see in open banking, right? It can be ways to help make and receive payments, whether it's on a business-to-business side or consumer payments, P2P. It's, providing loans to consumers or small businesses and all other types of kind of financial services that might be provided. Next slide. One area where there is a little tweak between kind of open banking and kind of the bank partnership model is kind of the underlying reason why a lot of fintechs are partnering with banks. And so I think it is worthwhile to just kind of touch on that briefly. In order to provide a lot of financial services, you either have to be a bank or a credit union or kind of a licensed and chartered entity like that, or you need to be a licensed money transmitter, or perhaps a state licensed lender, right? So for a lot of non-banks that want to get into moving money, services that involve moving money or lending to consumers or businesses, there's a lot of licensing that goes along with that. Then there are state by state specific issues that they have to deal with. And so for a lot of non-banks, partnering with the bank that has the authority to do those activities, that also has federal preemption that is relevant in a lot of cases, is a very attractive way for the fintech to be able to kind of leverage the technology and maybe the customer acquisition functions that they have and partner that with the bank that ends up providing the financial service to the consumer. But again, the key issues here always come back to, what kind of data is being used and shared, what kind of consent is the fintech getting on the front end, and then what kind of data security is being provided, from start to finish in connection with providing that service. Next slide. And just as we've seen the CFPB start to get more focused, or maybe I should say increasingly focused on data security and related issues and really looking at kind of the open banking model, we're also seeing the federal regulators, particularly the banking regulators, really start to hone in more on the bank partnership model. And there was a recent disclosure of an agreement between the OCC and Blue Ridge Bank, which has been a large kind of fintech partnership bank that is focused on concerns about the bank's third-party risk management, information technology control, and various different types of risk governance. As part of this, the CFPB, the OCC basically is limiting the bank's ability to expand into new relationships and requiring a host of improvements to their partner oversight. So having a written program to focus on that third-party fintech relationship, improving AML compliance, having more IT improvements put in place, just a lot of focus on kind of the blocking and tackling that goes into providing these bank partnership services. And again, the data security, information technology concerns were a big part of that. Next slide. And notwithstanding that particular order, it's not to say that the banking regulators and even the CFPB, for that matter, haven't been focused on third-party oversight for a long time. I mean, this has been an issue that the bank regulators have been pushing for years, issuing guidance about the need when you're partnering with a third party to perform due diligence. And a lot of that is looking at their data security practices, IT, how they're managing all of that. It's the type of, I'm sure it's going in and looking at the type of issues that Jeremy and Ross were talking about. Are they managing these kind of best practices? Have they put them in place? Are they following the guidance and having that be a big part of the decision-making process as to whether or not to partner? There is ongoing rulemaking that the bank regulators are doing on third-party risk management. No rule yet, although the comment period did close last year, so that is something that we're waiting to see and see what kind of guidance comes out from that.
And with that, thank you all for listening in. If you have any questions, here's our contact information. Feel free to reach out to us. And once again, the CLE password is CFPB 2022. I want to thank Andrew, Jeremy, and Ross for joining me, and I wish everyone a very good weekend.
Thank you.